What was the nature of their complaint?
Briefly, that there was a loud generator coming from the neighbor's house to the west of them.
Who would the neighbor be?
Christopher Daffron.
Are you familiar with Mr. Daffron?
I am.
Did you have contact with Mr. Daffron that day?
I did.
Please describe the actually, let me back up just a moment. Judge, did somebody deliver an exhibit that I asked to be marked as Exhibit 1?
We do have somebody here with something.
Okay. Mr. Gramstrup, I emailed a copy of this image to you as well. Did you receive that?
I have it.
Deputy, I'm handing you a copy of what's been marked in court as Exhibit number 1. Do you recognize what that is?
I do.
What is that?
It's a satellite image of Mr. Daffron's residence.
Is that a true and accurate representation of Mr. Daffron's residence and at least that portion of his property?
It is.
What is the road there running in front of his residence?
That's Newman Road.
So on June 6th of, June 27th of 2020, this is a residence you went to?
It is.
Did you make contact with Mr. Daffron?
I did.
What, if anything, did you learn during your contact with Mr. Daffron?
Regarding the initial contact or the whole thing, or?
Yes, please, I guess, please describe your initial contact with Mr. Daffron.
Okay, my initial contact is that I parked my patrol vehicle in the driveway there on the image. And then Sergeant Colford with also another deputy sergeant with the Douglas County Sheriff's Office was with me. We pulled into the driveway, and then on the image, there's a yellow line that points from basically the road to Mr. Daffron's front door that I approached on foot, and I knocked on the door. There is a 4 or 5 step porch that I had to walk up to knock on the door, and then I came down to the ground level until Mr. Daffron came to the door. I could see that he was in the house. It looked like that he was walking around in the house in the kitchen area.
So as you pulled into his driveway, were there any gates or barriers across the driveway?
No.
Were there any gates or barriers between the driveway and his residence?
No.
You approached the house. Did you knock at the door?
I did.
What did you observe next?
I saw Mr. Daffron inside. Well, there was a window to the right or east of the front door, and I could see that he was inside. I saw that he walked up to the front door, and I saw him put something down kind of in front of the window by a chair. I wasn't sure what it was at that time.
Did Mr. Daffron answer the door?
He did.
Did you have a discussion with him?
I did.
At any point was he asked what he had placed on the floor?
Yes.
What was his response?
He said he didn't know.
What happened next?
When he said he didn't know, Sergeant Coulthard was standing there with me, and he said it looked like a beer can. And then I asked Mr. Daffron that, and he said he admitted it was a beer can.
What did you do next?
Basically, I dealt with the neighbor complaint kind of at that point and asked him, hey, can the generator be shut off? And he said, yeah, absolutely, shut it off. And he invited myself and Sergeant Colford to walk into his field towards his camper, and then we went with him, and he shut the generator off.
What happened after he had shut the generator off?
Due to the beer can admission, and then I had already known that he had bail conditions of no drinking. for a previous case. I asked him if he would, while walking back to the truck, I asked him if he would submit to a preliminary breath test.
Did he?
He did.
What were the results?
0.11.
At this point, prior to voluntarily taking the preliminary breath test, at any point did you or Sergeant Coulthard tell Mr. Daffron that he was under arrest?
No, not prior to that. No.
Did either of you place hands on him?
No.
Did either of you handcuff him?
No, not until after that.
After the preliminary breath test?
After the preliminary breath test, sorry, yes.
And I'm not sure if I asked you, but what was the result of that?
A 0.11.
No further questions, Your Honor.
Mr. Transfer question.
Thank you, Deputy. I'd like to break this down in a little bit smaller steps. You responded there on June 27th, and that was a neighbor complaint, correct?
Yes, sir.
And the complaint was really twofold. One, that they were complaining Mr. Daffron's camper was too close to their property line, and that secondly, he had a generator that was running. Is that right?
Yeah, I think so, yes.
Approximately what time of the day was that?
I would have to refresh my memory with the report, but it was sometime after 8 p.m., I believe.
Okay. And how far were you able to observe the camper from the complaining witness's home?
Yeah, I could see the camper in the yard or in the on the property of Mr. Daffron, yes.
Did you do any estimations at that time as to how far the camper was from the property line?
I probably did. I didn't document that exactly how far I thought it might have been.
Okay. Would it be fair to say that it was maybe like 400 to 500 feet?
It wasn't 20 feet, I can tell you that. I mean, it was pretty, it was several, maybe a couple hundred to 400 feet, maybe. If you wanted me to put a number on it, it was somewhere in there. I don't remember exactly.
All right. In your mind, the placement of the camper was clearly not an issue. Is that right?
Well, I guess that's depending on what you mean by that, an issue as far as.
Well, let's put it this way. The placement of the camper where Mr. Daffron had it, he wasn't violating any law or ordinance by the placement of his camper. Is that correct?
Not to my knowledge. The camper was on his property.
All right. And there was no bail condition indicating where his camper could be, true?
Yeah, I do not remember seeing a specific, hey, Mr. Daffron can't put it here or there or.
Okay. And the same thing is true with the generator. There's no law or ordinance that he was violating by having his generator where he had it, correct?
And there was nothing in the bail conditions that said, where you can put the generator or can't.
Right. And he was not breaking any law or ordinance by doing that either, correct?
Not to my knowledge, no.
Okay. And would you say it's not unusual for people in the county, especially using a camper, to be running a generator?
It is a common practice that, to my knowledge, yes, that if you have a camper, you may run a generator, you may not.
Okay. Now, the complaining witness actually wanted Mr. Daffron arrested simply because he was running a generator. Isn't that true? I
do remember one of the complainants, I'm not sure if it was Mr. Stavs or Miss Christine, that mentioned about they should be arrested for harassing for the generator, specifically asking me that, correct?
And you explained to them, whoever that was, him or her, that there were no bail conditions that prohibited him from running a generator, correct?
Correct.
Now, the generator was farther away than the camper from their home, right?
I didn't necessarily document that specifically, but I don't remember that. I felt like it might have been closer, but okay. Yeah, I don't remember that specifically.
You were actually out there the night before on a complaint based upon the same two reasons, correct?
I was out there the night before for something. So I did not read that report specifically because it didn't have to. I didn't feel like I needed to because it wasn't. This was about a bail jumping deal.
Okay.
So I don't remember much about that one.
Do you have that report from June 26 with you?
The one from the night before, I don't.
Okay. If I told you that the complaint was the same from that night, placement of the camper and the running generator, does that refresh your memory at all?
I don't not believe you on that specifically. Again, I don't remember independently what it was specifically about. I mean, that sounds about correct, yes.
Okay. And you remember going over to try to talk to Mr. Daffron the night before about it as well, correct? And you talked to his son, Richard?
Your Honor, I'm going to object to this line of questioning. I don't see how it's relevant to whether a search or a violation of the Fourth Amendment via a search occurred on June 27, 2020.
Mr. Gramsci?
Your Honor, if the state's relying on the plain view doctrine as an exception to the exclusionary rule, there's one of the first factor that the state has to overcome is the prior justification for being there. My questions go to what I believe to be true, if the officer is allowed to answer, that he went there for the same reasons the night before and found no violations of law or any harassment, and subsequently went there back for the same reason the second night, which is incongruent with a justification for the intrusion.
Objection overruled. Go ahead, Deputy, if you can answer.
So when you mentioned Mr. Daffron's son, I do remember, yes, going to talk to him in person. And I feel like, if I remember right, Mr. Daffron's son, Richard, I believe, was on his tractor or lawnmower of some kind and drove up to me in the driveway, and we spoke in the driveway.
Okay. And after you had that conversation and looked things over, is it true that you advised Richard that you were not going to submit charges to the DA for harassment for that incident?
I do remember that conversation, yes.
Okay. Now you're back the next night on June 27th for the same two complaints, and you felt it necessary to go over and talk to Mr. Daffron again, correct?
I did. The generator was loud and bothering neighbors, and I would do that anywhere.
Didn't you indicate the night before in your report that you could hear the generator from their yard, but it was not extremely loud at the time, it just could be heard? Do you recall that in your report?
I feel like that's in my report for this day of incident that we're talking. It was there.
Okay.
Yes.
All right. So if I'm to understand correctly, you had the same complaint on the 26th, and you went over to speak to Mr. Daffron and determined that there was no probable cause for harassment, correct?
Well, to be fair, I spoke to Mr. Daffron's son.
Okay.
In person, and then I believe Mr. Daffron called me later that night. I believe we had a similar conversation.
And based upon that, you determined there was no probable cause to charge or arrest Mr. Daffron for harassment, correct?
Correct.
And then you went back to talk to Mr. Daffron the next night for the same two complaints. What, if anything, was different about the complaints that you felt the need to talk to Mr. Daffron on the 27th?
Well, if I remember correctly, and I can look at my report, I also put I put something to the effect that the generator wasn't necessarily rumbling their home or anything, but it was an annoying noise, and it was late at night. And when a neighbor complains that something's annoying them from another house next to them, it's my job to try and mediate the situation and go speak to him. And subsequently, he agreed it was running and he'd shut it off.
Were you aware on the 27th when you went over to see Mr. Daffron of any difference in circumstances as to the placement of the generator or the camper?
I'd have to read that first report. I don't remember if it was in a different place. Well, actually, yes, I do remember that there was an additional generator the second night. that he had bought another generator. And so there were multiple generators on the property at this point. The night of the 27th. So that I do for that now, yes.
And that was but there's just one generator running, correct?
It was a different generator than the night before.
Okay, you were informed that one was supposed to be quieter than the other generators he had, true?
That's what he said, but it was still loud and annoying. So
So in any event, you went over to speak to Mr. Daffron, correct?
I did, correct,
You knocked on the door and you saw him inside through a window.
correct,
You were still outside.
correct,
He came to the front room and you were still observing him through the window, correct?
correct,
And at that point, you say you saw him set something on the floor by a recliner and then he answered the door, true?
correct,
And as you testified today, you were not sure what that was at that time.
correct,
And when you saw that, you were still observing through the window, true?
correct.
Fair to say at that point, you had no idea what it was.
I didn't know what it was, correct.
Okay. Then you had some discussions with him about the camper and the generator. And at that point, he's out, basically outside his front door, and you're off the step, sort of down on the ground, correct?
Yes, sir.
After you had that conversation with him about the camper and the generator, then you asked him what he put on the floor before he answered the door, right?
Yes, yes, sir.
And that's when he said he didn't know.
Correct,
You would agree that at that point you were conducting an investigation to find out what he placed on the floor, correct?
I was curious, correct, yes,
Sure. That's when Sergeant, and he said he didn't know then, right? He said he didn't know what he placed.
yes,
And that's when Sergeant Coulthard kind of pressed him, and then he admitted it was a beer, true?
I believe Sergeant Coulthard actually told me it looked like a beer. I don't know if he said it loud enough to where Mr. Daffer can hear them, but then I followed up with that.
Give me 1 second here. Okay. And then subsequent to that, you asked him to submit to a PBT, and then you questioned him further about how much he drank, correct?
Correct, correct,
Then you arrested him and put him in handcuffs.
correct,
And then at some point, you went into the house, and the first time you were in the house, Mr. Daffron was in handcuffs at that point, correct?
correct. He had asked me to help him go in the house.
Right. And that's when you discovered it was a Miller High Life, and you indicated it smelled and poured like beer, and confirmed that it was beer then, correct?
Correct.
So would you agree that you're finding out what exactly he put down, which you didn't know at the time what it was a result of your investigation?
Yes, correct. Sergeant Coulthard said it looked like a beer, and then Mr. Daffern admitted it was a beer.
Okay. And as a result of this whole interaction, the only probable cause you found was the alcohol violation of his bail condition, true?
That's what he was charged for, correct?
Right. You didn't find probable cause of harassment or anything else?
No.
All right. Those are my questions. Thank you.
I just had at least one question. Deputy, what was your motivation to go onto Mr. Daffron's property?
Well, I had a complainant that complained that a noise was very loud coming from the neighbors. There's ongoing issues between the neighbors, and I'm there. My main motivation is to try and keep the peace and try and mediate the disruption and disagreement between two people, so it doesn't get any worse or more things don't happen.
Did you go on Mr. Daffron's property or approach his residence with a motivation to investigate a crime?
I would say no. My main motivation was to try and help solve a neighbor dispute and neighbor problem. And then anytime I'm anywhere, I'm always investigating to see if there's a crime. But I would say my main motivation was to go and try and help neighbors dispute an issue.
And I just want to make sure I have it down. So you and Mr. Daffron went and he turned the generator off?
Yes, sir.
And was it after you took care of that complaint, because that actually probably solved the neighbor dispute? Is that when you took Mr. Daffron into custody and did PBT, or I guess I'm confused about the timing of everything.
No, after Mr. Daffron invited me to the property and turned the generator off, and he turned the generator off, we were walking back to my squad car in the driveway. And I asked him while walking back, sir, would you submit to a BBT? And then we got back to my car in the driveway, and he was just standing outside my car, and he submitted to a PBT. And then while I was there closer to him, I smelled alcohol. He submitted to the PBT. I determined the bail violation, and then I placed him under arrest.
At what point did you know it was a condition of his bond that he not possess or consume any alcoholic beverages?
I had known that before, because I probably for a couple things. I don't remember if I had looked at it before I went to the call, or maybe the date. I might have known it before anyway, because I knew kind of the ongoing issue. But also Mr. Staves and Miss Christine also had pointed out to me the bail conditions, because they had called me about the generator and the harassing, and then it's also in the bail conditions there too when they pointed it out to me.
And I know that there's a history behind these people. Apparently, I don't know all the history. I don't need to know all the history. Is this something you treated differently because there was history, or did you treat it the same as if you have any neighbor complaints such as this?
No, not at all. My job as a deputy is to enforce the law and trying to keep the peace in the county. And if there's neighbors that are having a dispute, whether a deputy or not, I want to walk to the door and say, Mr. Daffron, your generator is loud. Can you, try and help keep the peace? And that way we don't have a problem later.
All right. That's all the questions I have. Mr. Lelord, did you have any redirect?
One moment, Your Honor. Yeah, just briefly, Your Honor. Deputy, your last response to the court regarding, I think you testified regarding investigating or enforcing the law, and something about maintaining the peace. Regarding these parties, Mr. Daffron and Ms. Christine and Mr. Staves, have you and or other deputies responded there previously on neighbor complaints?
Yes.
In fact, the Douglas County Sheriff's Department has responded there many, if not dozens of times, correct?
Yes, many times, yes.
During your law enforcement career, have you responded to other neighbor complaints where you have not arrested the neighbor for a noise complaint or similar type issue?
Oh, absolutely, many times.
Did you just walk away, or did you attempt to do something?
Whenever I get a neighbor complaint of any kind, I try and mediate the peace between two people.
To confirm, after you placed Mr. Daffron under arrest, why did you go into the residence?
I don't remember specifically the specific request that he had. I remember he was cooking, his oven was on, he wanted his oven shut off, which is a huge safety issue. I don't want the oven on either, especially if he's asking me to go in and shut it off. I don't remember if we got shoes for him. I think he grabbed his cell phone. We also helped put the dogs he had like a pet gate there in the house, and he wanted the dogs on one side. He had asked us for help to help him.
So Mr. Daffron asked you to go into the house to take care of things before you took him to jail?
Correct.
When you pulled into his driveway, were there any signs posted that said, "Stay out, don't drive on my driveway," anything like that?
No.
No further questions. I'd offer Exhibit 1, Your Honor.
Any objection, Mr. Gramstra?
No, Your Honor, and I have no follow-up.
All right, Exhibit 1's received. There's no other questions. Mr. Lure, any further witnesses or evidence?
No, Your Honor. You can.
Mr. Grafstrup, any witnesses or evidence you want to present?
No, Your Honor.
All right, Mr. Lure, argument?
Your Honor, I think the threshold issue here is essentially this is a plain view case. The deputy was investigating a neighbor complaint. That complaint was the loud generator. He did not believe that to be a violation of the bond conditions. However, as he testified, his job as a deputy is not just to arrest people and put them in jail, but is to solve problems so we don't have continued issues that lead to complaints. The deputy drove to Mr. Daffron's house, did not have to go through any gates. The deputy, in essence, was in a location that he surely had a lawful right to be when he knocked at that door to speak to Mr. Daffron. He was in a location where a delivery person, a salesperson, anybody that may want to speak to Mr. Daffron would logically be. Because he's there in a lawful place that he's allowed to be, he observes Mr. Daffron place something on the floor, asks him about it, and Mr. Daffron confirms that it's a beer. There was no search. There's no infringement upon Mr. Daffron's Fourth Amendment rights in any way, shape, or form. We would ask that the court deny the defendant's motion.
Mr. Grafstrup.
Thank you, Your Honor. Well, first of all, court's aware that a warrantless search is per se unreasonable under the Fourth Amendment, except only under certain well-defined circumstances, one of which would be the exclusionary rule, the plain view doctrine. There's an exception for the plain view doctrine. I think clearly this does not fit that exception. Looking at State v. McGovern, 252 Northwest 2nd, 365, 1977 case. I apologize, I don't have the Wisconsin side handy, but there are 4 prerequisites that must be invoked, that must be met to invoke the doctrine. And all 4 elements, all 4 prerequisites have to be present. First is there has to be a showing of a prior justification for the intrusion. Although the officer may have a right like a delivery person because there's no blockage or signs or fences prohibiting the officer from coming upon Mr. Daffron's property, there's no justification for him to be there. He was there the night before for the same 2 complaints, determined that there was no violation of the law, determined that there was no harassment, and went on his way. The next night he comes back, the night in question on June 27th, and it's the same 2 complaints. The officer could identify today no circumstance or fact that was any different from the night before. So there's no reason, no legal justification for the officer to go over and attempt to speak with Mr. Daffron in the first place. His camper is legally placed. The generator is legally placed. It's not violating any law or ordinance. Secondly, and most important, well, just as important, is that the object or the illegal, the evidence that is determined to be illegal must be in plain view. This wasn't in plain view. It's not enough to say that ultimately they determined that it was beer and therefore it's in plain view. If that's not the standard. Anything seized when it's seized is going to be in plain view. It has to be in plain view at the time the officer notices it. The officer testified today that when he saw him put it down on the floor, he had no idea what it was. He set something on the floor by a recliner, then answered the door. He did not know what it was. That is not plain view. The third um, prerequisite is that the discovery must be inadvertent. It cannot be the result of an investigation. Although the state argues that there was no investigation, the officer admitted it was the result of an investigation, and his testimony clearly demonstrates it was the result of an investigation. The officer didn't know what it was. He then asked him what it was. Mr. Daffron responded he didn't know, and then he was pressed. He was questioned further. That completely belies the argument that it was in plain view and that it wasn't an investigation. He then asked him to do a PBT. That's further investigation. Only then, after he was pressed and admitted, they went in the house at the time Mr. Daffron's in custody, and only then confirmed, in fact, that it was beer. That was Miller High Life. It smelled like beer and it poured like beer. So it's the result of an investigation, not something that was plain, open, and obvious. This isn't a case where officers invited into a home or has a legal reason to come into a home and, for example, sees a dugout plain in open view and sight on someone's coffee table and asks who it belongs to. It's a completely different situation. The fourth prerequisite is that the item seized, together with the knowledge of the officer, would provide probable cause to some type of criminal activity. We concede that prerequisite exists. However, it only exists because of the violations of the first three prerequisites. So based upon that, Your Honor, we would ask that the court grant our motion, suppress all physical evidence and the statements, all derivative evidence that flowed from the investigation on the night of June 27, 2020. Thank you.
Thank you, Mr. Gromstrup. Mr. O'Lore, any response? I don't know if you're talking or not, but your mic is muted.
Can you hear me now, Judge?
Yes.
Okay, my apologies. I've not had a chance to look at the McGovern case. I guess I would, at this point, based on the lack of any citation in Mr. Gromstrup's motion originally, I did not see that case, so I have not had a chance to review it at this point. Regardless of whether the deputy immediately realized the item being set down was a beer can or not, the deputy was having a consensual encounter with Mr. Daffron to ameliorate the ongoing neighbor complaints and issues that have been going on. Mr. Daffron was not in custody, responded to the deputy's questions. That included, was that a beer? At that point, obviously, he knew it was a beer. There was not a search that had occurred prior to that point. And I guess that's the only thing I'd add at this point.
All right, I've heard the arguments. I mean, the interesting part about this case is, I guess not so interesting, but the standard is, okay, was the deputy on the premises lawfully? And in my opinion, is absolutely. Deputy and law enforcement's job is, as the deputy stated, to keep the peace. There's times where you try to mediate these disputes between neighbors. It's perfectly consensual. The officer didn't break into houses, break down doors. There's no trespassing sign. So the first question is, was the deputy there lawfully? And the answer to me is a resounding yes, at least under, the community caretaker standard or just in general with keeping the peace. He was within any confines of a delivery driver or things like that. The next issue was the evidence in plain view. As far as if we're looking at this as some type of plain view doctrine, this is also kind of a nuance. This is a little bit different. This is a consensual encounter, but as far as it being plain view, the beer can was there. The deputy Coulthard apparently said is that, it looks like a beer to me or something like that. And then he responded and admitted to it. And this is all in the circumstance where there's no Fourth Amendment or Fifth Amendment being implicated because there's no custody. They're there, and I find the deputy credible. He's there to try to keep the peace. Sounds like there's quite the dispute going on if they've been called multiple times. And he's trying to do his best to make sure there's no problems for either party. So the evidence was there, could be seen by Sergeant Coulthard. And as far as it being inadvertent, I think the intent behind that is, okay, what was the motivation of the deputy when the deputy went there? The motivation to me, again, was, as he stated, to keep the peace. Now, it doesn't mean that you're going to ignore everything else that's going around you. If you think you're understanding a violation, it doesn't require that the deputy just put blinders on and ignore everything else. The deputy still can gather information if it supports his position. But what he wanted to do was to keep the peace, and that's what he, continued to do by getting the generator shut off. And Mr. Daffron, complied with it and did a reasonable thing by shutting the generator off. And then that's when the investigation started taking the other road. Hey, we saw the beer can. Do you want to take a PBT? And he consents to it. He consents going in the house, help him out. So in my opinion, and as far as probable cause goes, the minute that Deputy Coulthard sees that it's a beer can, there's probable cause. The defendant put down a beer can, then he acknowledges it's a beer can. There's probable cause at that point, but they wait to do anything until after they've completed the encounter. Certainly the deputy had an opportunity. He didn't have to do anything. It was his intent, as he indicated, was to keep the peace. And this just happened to be that Mr. Daffron was violating his bail, and he was in a position where the deputies were able to observe that lawfully. So the motion to suppress based upon any Fourth Amendment violation, or quite frankly, I think I've heard enough, any Fifth Amendment violation is denied. Mr. Lalore, would you do an order consistent with this opinion?
I will, Your Honor.
And then as far as scheduling, what else did we want to do today, Mr. Lalore? I don't think we have a different thing on anything else on the calendar.
I guess I would defer to Mr. Gramstrup. I think in the underlying case, I believe, correct me if I'm wrong, Mr. Gramstrup, but I think I've already extended an offer on that matter.
Right, and that matter needs to be scheduled for trial.
Okay. So I'll schedule the matters for trial. Mr. Lalore, when would you be ready to try the cases?
I guess I'd defer to the court schedule. I do have I would anticipate this would probably be out in November, December timeframe.
That's why I'm asking, when would you be ready to try it? And then I can start looking sometime thereafter.
I think we'd be ready by December, Joe.
Mr. Gramstrup, when would you be ready to try it?
I'd be ready in December.
All right. Let's see. I've got December 1st at 8:30. We could either, do you think one day, Mr. Lalore, or 2 days?
I think to be safe, 2 days.
Yeah, I would agree. There's the underlying case. There's obviously more than just one incident to be covered as part of the stalking count. So probably 2 to be safe.
December 1st and 2nd work, Mr. Lalore?
One moment, Judge.
We'll go off the record for purposes of scheduling.
I believe it would at this point, Your Honor. I'm, without pulling up my report on the underlying case, I know I've got multiple law enforcement, but at this point, I think that should work.
Mr. Groundtrip, December 1st and 2nd?
That works for me.
And then pre-trial November 13th at 3 o'clock?
Let's see. That's fine.
Mr. Lalore?
That was November 13th, Judge?
Yes.
That should be fine.
All right, we'll go back on the record. I spoke to the parties off the record. We decided on jury trial, December 1st and 2nd, with a pretrial conference, November 13th at 3 p.m. Obviously, the pretrial conference defendant needs to be there in person and also for the jury trial. Mr. Lalore, those dates all work for the state?
Yes, Your Honor.
Mr. Gramstrup, those work for you?
Yes, they do.
Mr. Lalore, those work for you?
Yes, Your Honor.
All right, I'll get a scheduling order out the next week or so. I think that's it for today. Anything else, Mr. Lalore?
Well, Your Honor, thank you.
Anything else, Mr. Gramstrup?
No, Your Honor, thank you.
All right, thanks. Have a good day.